A very good morning to all of you present here. Justice ML Mehta, uh, Advocate Vivek Narayan Sharma sir. Uh,
मेरा other phone.
Today we are in the finals of Legal Foxes and Gemtech First National Virtual Moot Court Competition in association with Delhi Legal Services Authority South. Today we have team 56 versus team 33 in the finals. Devshri, can you please tell the rules of the competition?
There are two rules. First, you have to keep your videos on for the whole proceeding, and second, you have to close your mics until you are saying something. You have to close your mic. Okay, we can
With,
start.
with, the, permi- with the permission of your honor, we can start with the session.
Yeah, I think we can start. I think we are already late. We can start. I welcome to all of you to this final round of moot court competition. So wish you all the best to all the participants who have been able to make to this final round. And I hope that all of you will participate in a very good spirit, which will be taken to be as a learning spirit. And I hope all of you will do your well and you're well prepared. So wish you all the best again. And we can start with the proceedings as you may decide.
The council seeks permission to begin, Your Lordship.
Yeah. You continue, please. You're welcome to start.
Much obliged. Greetings to the bench. This is the council on behalf of the petitioners in the case of Nari Raksha Samiti versus the state, clubbed with Advocate Badrinath and others versus State of Bhavani, and the parents of the accused versus the Frank Owl and the Mint. The council seeks permission to address the bench as Your Lordships.
Yes, you can carry on.
Much obliged. If your lordships are aware of the facts of the case and the statement of jurisdiction, the council seeks permission to proceed to the issues raised in the arguments advanced.
Yeah, carry on.
Much obliged. Your lordships, in the current instance, there are 5 issues which are being raised. The first 2 will be dealt with by the current council, whereas the next 3 will be dealt with by my co-counsel. The first and second issue are whether the petition is maintainable before the court, and secondly, whether Section 74(3) of the Juvenile Justice Care and Protection for Children Act 2015 is constitutionally valid. Your Lordship, with respect to the first issue, the court has already clubbed the petitions and it has been posted for argument. Ordinarily, such an issue shouldn't arise. Yet, as it's the duty of the petitioners, we submit the following arguments to reaffirm the maintainability of the petitions. Your Lordship, it is contended that the current petition is maintainable before the court. The same is argued in a threefold manner. Firstly, the petitioners have local standing. Secondly, the fundamental rights of the petitioners have been infringed. And lastly, the existence of an alternate remedy is not a bar to the current petition. Your Lordship, in the writ petition is maintainable against respondents 3 and 4 in the current issue. Article 21 of the Constitution essentially guarantees the right to privacy and reputation to its citizens. In the instant matter, respondents 3 and 4, who are reputed media houses, with blatant disregard to the same, have not only disclosed the names of the children of the petitioners who were alleged accused members in the Bros locker room incident, but has also disclosed other details. And this has in fact led to violent protests and attack instigated against these families. The same can be identified in para 11 in the Moot proposition. This, Your Lordship, has violated the right of the petitioners and their children to live with dignity, reputation, and privacy. Moreover, Your Lordship, it is understood that respondents 3 and 4 dignity do not fall under the ambit of state under Article 12. Yet, the Council would like to draw Your Lordship's attention to the case of Ramakrishna Mission and others versus Cargo Punya, wherein which it was held that all organizations which perform a duty of public nature or of public importance are amenable to the writ jurisdiction. Moreover, Your Lordships, in the case of ABC versus Commissioner, wherein the facts of the case are very similar to the current incident. Reputed media houses like Hindustan Times and Aaj were treated under the writ jurisdiction of the court. Your Lordship, the press and media essentially perform a very important public function and has the capability to influence the minds of the public. And they're in fact considered to be an important pillar of our democracy. Therefore, the current petition is maintainable again. Moreover, Your Lordship, the letters which have been presented by the group of advocates, including Advocate Badrinath, and the petition filed by Nari Raksha Samiti in the High Court are both in the nature of a public interest litigation. As your lordships are aware of the importance of public litigation and the pivotal role it has played in our legal systems, and it is understood that a person who acts in a bona fide manner and having a very sufficient interest in maintaining an action for judicial redressal for a public injury which has been caused and thereby putting the judicial machinery into action is considered to have a locus standi. Moreover, Your Lordships, this very court in previous instances have considered has treated a letter as a writ petition. For example, in the case of PUCL versus Union of India. Your Lordship, there is no extraneous motivation on part of the group of advocate as well as the NGO. And in fact, they've acted in a pro bono publico manner to redress the legal injury which has been caused. Therefore, the petitioners do have locus standi. Moreover, Your Lordships, the fundamental rights of the petitioners in the current instance have been violated. The right under Article 19 and 21 have been infringed. The same is dealt with in detail in issue number 4 by my co-counsel. Furthermore, Your Lordship, the existence of an alternate remedy is no bar to the current petition. The right to approach the Supreme Court under Article 32 is guaranteed by the Constitution of Bhavan. Furthermore, Your Lordship, the rule of an alternate remedy is just a rule of discretion and not a rule of jurisdiction, and the same cannot be considered as a ground to bar the current jurisdiction, bar the current petition. Furthermore, Your Lordships, it has been held in previous instances that a petitioner seeking to enforce their fundamental rights can directly move to the Supreme Court without going to the High Court. In the current instance, there has been a gross violation of the fundamental rights of the petitioners. Therefore, the petition is maintainable before the court. If Your Lordships are satisfied with the arguments provided for issue 1, the council seeks permission to move to issue 2. Sorry, Your Lordship.
You can, Meenakshi, you can move on to issue number 2.
Much obliged, Your Lordships. The second issue is whether Section 74(3) of the Juvenile Justice Care and Protection Act of 2050 is constitutionally valid. It is contended that Section 74(3), which essentially provides the punishment for the prohibition on disclosure of identity of minors, especially children in conflict with law, is constitutionally invalid. The same is argued in a twofold manner. Firstly, that it is violative of Article 14 of the Constitution. And in addition, the punishment prescribed is inadequate in nature. Your Lordship, Article 14 of the Constitution essentially guarantees the right to equality as well as the equal protection of law, and is in fact a basic feature of the Constitution. Moreover, Your Lordship, equal protection essentially means the right to have equal treatment in similar circumstances. That is, likes are to be treated alike, even in privileges conferred to them or the liabilities imposed to them. Moreover, the doctrine of equality essentially applies to all who are equally placed, be it even if they are found guilty. Also, Your Lordships, if a classification is made under Article 14, the same must pass the tests of intelligible differentia and rational nexus. In the current instance, the provision Section 74(3) does not pass both. The punishment provided under Section 74(3), which for the prohibition of disclosure of identity of children, especially children in conflict with law, by any person or the media, is a maximum imprisonment of 6 months or rupees 2 lakh as fine, or both. Your lordships, this is not only inadequate in nature, but also unequal in comparison with other similar legislations with a similar intent. For instance, the council would seek to draw your lordship's attention to section 228A of the IPC, as well as section 23(4) of the POCSO Act, wherein which punishment is provided for such identity disclosure. Your lordship, under both these provisions, the punishment provided is almost the same, wherein which the minimum imprisonment period provided is a period of 6 months, and fine or both. Your lordship, it is very pertinent and very important to note that the minimum threshold provided under both these provisions is the maximum provided under the JJ Act. Furthermore, there has been no cap which has been put on the amount of fine. Your lordship, a close reading of all these provisions, one can understand that the legislative intent behind all three provisions are the very same. Essentially, to protect the identity of those whose identity, if known to the society or if disclosed to the society, will lead them to face unreasonable treatment by them, unnecessary ridicule, social ostracization, and makes the rehabilitation back into the society extremely difficult. And this also is an attempt to protect their right to privacy. Therefore, if a media or any person discloses the identity of any of these vulnerable persons, it is essentially the same offense which is being committed, for which different punishments are being provided. Your lordship, there exists no intelligible differentia in such differential treatment of the media, and not only different, but also a lower threshold, a lower quantum of punishment which has been given for similar offenses. Assuming but not admitting that there was no intentional classification which is being made, your lordships, the council fails to understand where there is a rational nexus between such differential treatment and the objective of the JJ Act. Your lordship, the best interests of the child, as well as the right to privacy and confidentiality, are guiding principles as can be found in section 3 of the JJ Act, based on which the JJ Act has essentially been made. And with such a lower quantum of punishment being provided in differential treatment of the media, section 74(3) is in no way in furtherance of the best interest of the child or the right to privacy and confidentiality. Your lordship, this leads me to my next point, which is section 74(3) leads to arbitrariness. Your lordship, arbitrariness is an antithesis of rule of law, equity, fair play, and justice. An arbitrary action can be one which has been done irrationally or unreasonably. Furthermore, the concept of manifest arbitrariness essentially determines if the legislature has acted in a way which is irrational or without an adequate determining principle. Furthermore, your lordship, when a particular statute on the face of it has not made any attempt at all to make a classification and yet has singled out a particular individual or a class of persons without them having a particular or unique characteristic assigned to them, the presumption of reasonableness in favor of the law can be instantly rebutted. Your lordship, in the current instant, it must be noted that the juvenile justice, section 74(3) has been a punishment which has been brought about in the 2015 amendment, and when the 2015 law and when the 2015 Act was brought in, your lordship, the current punishments provided under 228A of the IPC as well as 23(4) of the POCSO Act was still in existence, wherein which for the same offense, a higher threshold of punishment has been provided. Moreover, your lordship, this is not only arbitrary. Moreover, your lordship, POCSO Act also deals with minors, that is essentially individuals under the age of 18, as well as the Juvenile Justice Act also deals with individuals under the age of 18, wherein which the identity disclosure of these individuals is protected by both these acts. The punishment provided for the same are different in nature, and under the JJ Act, it has a lower threshold. This, in fact, causes discrimination on application, your lordships. Furthermore, the punishment which is provided is inadequate in nature, which might not lead to the deterrence which is aimed. Your lordship, The threshold, as the council has mentioned earlier, is the punishment provided is extremely low, which essentially leads to this punishment being exploited by reputed media houses for financial gains, as can be seen through various incidents occurring in the country, Your Lordship. This frequently threatens the right to privacy and right to life of these children, which is guaranteed by the Constitution as well as the very Act, Your Lordship. Therefore, imposing a punishment which is not adequate in nature will only do harm to justice, Your Lordships. Therefore, the council submits that the current provision, section 74(3), is not constitutionally valid. If your lordships are satisfied with the arguments provided by the council seeks permission to call upon my co-counsel to proceed with the arguments.
Well, Learned Counsel, there is one question. Well, the question is, you are arguing on the adequacy or inadequacy of the punishment provided under section 74. And number one, the question would be that in the present proceedings, there is neither any relief being sought nor any relief can be given regarding punishment. So this argument seems to be a little extraneous, number one. Secondly, how can inadequacy of the punishment be a ground of the law being unconstitutional? Do you understand the question, or should I repeat it? One is,
indeed, Your Lordship.
One is the inadequacy of the law. How can the inadequacy of the punishment can be a ground for declaring a law to be unconstitutional, number one? And secondly, in the proceedings which are before this court, there is neither any relief sought nor this court is going into the question as to the punishment to be awarded to respondent number 3 and 4. That is an issue which has to be determined in some other alternative remedy. So how do you relate this with the present proceedings?
Thank you so much, Your Lordship, for the question. With respect to the first question of whether inadequacy is a ground for constitutional validity, the council would like to state that inadequacy per se is not a ground of invalidating a provision based on constitutionally invalidating a provision, yet it can add to the fact of a provision being struck down as constitutionally invalid. The council in the current case has argued the invalidity of the provision based on its violation of Article 14, Your Lordship. And with respect to the second question which has been asked, the council humbly requests the court to strike down the provision instead of increasing the quantum of punishment. And therefore, Your Lordship,
No. The last point is stated that the court can enhance the punishment. What do you say?
Your Lordship, in the last portion, the council stated that the council seeks that the court constitutionally invalidate the provision. Therefore, a better provision can be drafted by the authorities, which is in consonance with other similar provisions as well as the provisions of the Constitution.
Okay, then your argument on the second part of the question seems to be beyond the domain of the proceedings which is present before this court. Because how under this present proceedings, the court can determine whether the punishment to be given to respondent number 3 and 4 would be as per JJ Act or other sections of the IPC, or it is inadequate under this section 74. Well, how can the two things can be mixed together? I mean, this is a constitutional provision you are talking about, and then there's another substantive law which provides punishment. Anyway, if you have anything to say further, that's okay. Otherwise, you can move on.
I hope I got Your Lordship's question in the right way. Essentially, Your Lordship was asking me that I was comparing the JJ Act and the IPC as well as the POCSO. I hope the council is right.
Yes. Yes.
Indeed, indeed, Your Lordship, there are three different acts, one being a welfare legislation, one being a substantive law. But it is understood that the legislative intent behind these particular provision is essentially the same, which is to protect these vulnerable individuals, Your Lordship. Therefore, in a light of in a way of comparing them in that line, it can be understood that there exists discrimination, Your Lordship. If your lordship is satisfied, the council would like.
Okay, okay, that's all. Thank you very much. Move on to the next.
Much obliged. Much obliged, your lordship. The council seeks permission to call upon my co-counsel to continue with issues 3, 4, and 5.
Yeah, please carry on. Thank you.
Much obliged.
Greetings to the bench. Your lordships. Before I start, just a mic check. Am I audible?
Yes, sir, it's okay. Fine. Thank you. Carry
on. Much obliged. Greetings to the bench. This is the co-counsel on behalf of the petitioners and will be dealing with the next three issues in the present case. The third issue in the present case is that the right under Article 21 has been infringed due to the publication of the news reports. The submissions for the same are made in a twofold manner, being firstly that forbidding their speech infringes their right to privacy, and secondly, they had no intention of making the chats public, and the attacks which have occurred on their family members infringe their right. Going to the first submission, your lordships, it is an established fact that right to privacy is a fundamental right and no sort of arbitrary interference can be done upon the same. If such an interference is done, then the person has the right to protect and preserve it. This implies that the members of the bros locker room in the present case and their family members both have the right to privacy in a similar manner as any other citizen of the country of Bhavan. Moreover, your lordships, it has been held in the case of state of Maharashtra versus Bharat Lal that any sort of interception of a private conversation needs to be done as per the procedure which has been established by law. Here in the present case, we see that firstly, their chats were taken without their consent and made public without their consent, and secondly, the disclosure of their details was also done by the publication agencies without their concern, and the same has brought a lot of hue and cry against the same, violent protest against their family members, and the same has affected their dignity and reputation. Moving to the second submission, your lordships, it is contended that every person has a right over their own personal data, which means that any sort of unauthorized or accidental disclosure of the same results in an infringement of their right over their personal data, which in turn infringes their right to privacy. Here we see that their data has been released without asking them about the same, without taking their consent, which to just show what their actions are in their own private right. Moreover, your lordship, the same another case is R.M. Malkani versus State of Maharashtra, in which it has been held that even if it is the government who is continuing with a surveillance of a private conversation, the same needs to be done in a restrictive manner, and it is upon the state to ensure that even if a person has committed a wrong, then their rights are infringed in the narrowest manner. Here in the present case, we see that even if you have to punish a person for their wrong, you need to ensure that their right is being infringed in the narrowest manner. But in the present case, we see that the children who are in conflict of law, their details have been disclosed by the agencies in front of the entire world, infringing their right to privacy and thus violating their rights. Moreover, your lordship, the aspects of good reputation and dignity form a very important part and parcel of right to life under Article 21. In the present case, for both members of the bros locker room and their family members, the right is getting affected. As it can be seen in the factual matrix as well, page 4, para 11, that violent protests were caused due to such publications, and the reputation of the family members and the accused both got harmed. Moreover, your lordship, one of the principles of the Juvenile Justice Act is the reintegration principle. The reintegration principle was basically brought in so that the juveniles, once they have served their punishment, once they have been counseled, once their sentence is over, they can go back and reintegrate themselves with the society as They have a long life ahead of them. However, due to the publication of these news reports, the same is bringing and attaching itself to disproportionate ramifications, and it is completely destroying the reintegration principle, as the same is majorly affecting the dignity and reputation of all these accused members. Moreover, Your Lordship, we also see that in the present case, the arrest which have been done, the same is also unlawful in nature, as under the JJ Act, no FIR can be filed or a case can be for any juvenile in cases when the imprisonment is less than minimum of 7 years. So, under the Juvenile Act, there offenses which are petty offenses, serious offenses, and heinous offenses. Petty offenses are those which the maximum imprisonment is for 3 years. Serious are those where the ranges from 3 to 7 years, and heinous are where the imprisonment is for more than 7 years. So only in case of heinous offenses they can be, or they can go ahead and an FIR be filed against them. However, the same has not been done in the present case, and an FIR has been filed. Therefore, it is humbly submitted that the right under Article 21 has been infringed due to the publication of the news reports. Moving to the next issue, which is that the right of freedom of speech and expression has been infringed in the present case. The submissions for the same are in a twofold manner, being firstly that the members had a right to express, and secondly that the conditions of decency and morality won't apply in the present case. Moving to the first submission, it is given under Article 19, subclause A, that every citizen has a freedom of speech and expression with them, and however there are in subclause 2, such restrictions need to be direct, they need to be rational, and they can't be far-fetched in nature. In the present case, we see that these restrictions applied on the private chats of the people who were not affecting anyone else. They were just having conversations within their own realm of privacy. If such a restriction is being applied on such a manner, the same is going ahead and defeating the purpose with which the right under Article 19 subclause 1 subclause A is being provided. Moving to the second submission, we see, Your Lordship, fact and the popular morality can never be used to deny anyone the enforcement of their fundamental rights. When we talk about the aspect of morality, the question of constitutional morality comes into play, and constitutional morality always prevails over public morality. The same has been held in the case of National Legal Services Authority versus Union of India. This is also famously known as the transgender case. One of the main principles of constitutional morality is that whatever a person does within the realms of their own privacy, within the four walls, the right should not be infringed and the same should not be invaded. If the same is being done, the right under a right of privacy. So here we see that not only the right under Article 21, but also right under Article 19 is getting affected. Therefore, Your Lordships, it is humbly submitted in the present case, the right under Article 19 is also getting affected. Moving to the third submission, Your Lordships, which is that the court is empowered to pass guidelines and directions in the present case. The submissions for the same are that firstly, the present act is inadequate in nature, and secondly, that the court is empowered to pass such directions and guidelines. Moving to the first submission, Your Lordships, the Information Technology Act 2000 was passed with the legislative intent that any sort of electronic communication, electronic crimes or electronic offenses are occurring, the same will be covered via this act. And even though there are provisions such as 67A which talk about publication or transmissions, there are no provisions in relation to cyber stalking and cyberbullying, especially cyberbullying, as there has been no definition given for the same. There we also see that a rise of number of cases show that IT Act does not have the provisions to deal with such offenses. In the present case, we see that such acts have occurred, and there is no provision to deal with the same. Moreover, Your Lordships, the same has in the case of Sharad Babu Degamarte versus Government of NCT of Delhi, it has also been held that in case there is an electronic offense which is taking place, the same will only be dealt by the Information Technology Act, as it was the legislative intent behind passing the same. Moreover, Your Lordship, the Council agrees that even though, this implies that even though Section 354D has been added in the Indian Penal Code by the amendment, but the same cannot be used in situations of such electronic communications. Moreover, Your Lordships, we also need to take into consideration the legal Latin maxim, which is generalia specialibus non derogant, which means that the specific law will always prevail over the general law, and in such case the IT Act will prevail over the IPC, which the same has also been held in the case of, the principle has also been held in the case of Govind Mills versus State of Bihar. Moving to the second submission, Your Lordships, it has been held in the case of Dayaram versus Sudhir Batham that judicial activism is a useful adjunct for democracy, and the same can be resorted by the courts when there is a question in relation to national interest or some remedial measures are sorted. Moreover, the court can go ahead and they can enforce the fundamental rights of a person, especially in cases when a legislation has not been laid down. Moreover, Your Lordship, even though separation of powers has been accepted by our country, the same is not there in a very rigid manner. And whenever necessary, the organs can go ahead and interfere and look into the functioning of each other organs. The court is also empowered to rectify any sort of lacuna which is present in the present legislation, and they can also direct that direct the union government if they want any sort of new legislation for the same. That for example, in the case of Vishaka as well, it was first the guidelines which came out, and it was later that the act came out. If your lordships are convinced, the council seeks permission to go ahead and go ahead to the prayer.
Well, Ms. Sharma, you had, in your submission, you had stated that the restrictions on the private chats, which were between a group of the boys, amounts to individual privacy, and the restrictions which have been imposed are not reasonable. And you have talked about constitutional morality vis-a-vis the public morality and public decency. Tell me one thing. How can you say that a group of boys will constitute the right of an individual? Well, the right of an individual privacy would be different than the right of a group of boys who are indulging in these kind of acts. How can a group say that I am an individual, so I am protected by the right of privacy? Can you explain this?
Your Lordship, the council contended that every individual who was there had given their consent that yes, we have to be there, and as their acts were not affecting anyone else, it was their own realm of privacy. They never intended to make the chats public. It was some other members, and the factual matter is silent of how the same went ahead, and members who wanted the same to go ahead. It was never their intention, and as they had given their consent for the same, that yes, we want to become be a member of such a group, was that yes, it was their own private decision, their own decision.
There is no submission that there was any consent given by any of the girls. I mean, this was a group created by a group of boys, and who started sharing all the personal things and personal shots of the girls known to them in their different relationships. So how can you say that these groups? It means that the group can be as large as any number of boys. They can do it, and they can always come and say, well, this is the individual privacy, and I'm protected, and so there should not be any restriction on my privacy. So I mean, in that case, you can increase the large number of groups. They can keep on increasing, and this today is a group of, let's say, 25 boys, and tomorrow it can be of hundreds and thousands, and then it can be university, whole of the university or whole of the colleges. So it means that all of them can claim to be protected under the right of privacy. So what do you think that there has to be?
Your Lordship, the council under.
Yes, please carry on.
Sorry. point of the council understands your concern about the same, but how we in the present matter see that every individual had given their consent, and if the same they have given their consent, the right to privacy comes into picture. Moreover, your lordship, the council agrees that even though there's any wrongful act which has been committed, the person should be punished, but that does not give any other person to go ahead and violate their right to privacy, or does absolve of them of their liability. For example, the same has been held in the case of Vineet Kumar versus Central Bureau of Investigation. The facts of the case are there is a person who was involved in in a bribery case. So here, to know and catch him, the people went ahead and intercepted his private telephonic conversations. The court, in this case, held that even though a person is committing a wrongful act, that does not absolve you to go ahead and infringe the right to privacy without following the procedure which has been established by law. So in that case, we see that even though any wrong act which has been committed, the same does not give anyone the right to go ahead and violate the right to privacy without following the procedure which has been established by law. I hope the
well, then that well, just last one. In that case, according to you, they should have taken the consent of the boys that we are going to publish your names, or we are going to circulate or publish in the media or whatever. So you said that without the consent, they could not have done it. And do you think that they would have given the consent if they would have asked for?
Indeed, your lordship, that was the main contention, that what constitutes a person's right over their own personal data. Nobody can take the same without their consent. And as my co-counsel also stated, that 74 subclause 3, no identity can be disclosed as they are juveniles and the same needs to be protected. For example, your lordship, in the Nirbhaya accused identity of the juvenile is still protected and nobody knows about the same. So keeping all these in mind and giving you an example, the council contends, your lordship, and submits.
Yes, fine. Thank you very much.
If your lordship is convinced.
Yeah. Thank you, Sharma ji. Thanks a lot.
Yeah, Mr. Ram Sharma.
Your lordship,
am I audible?
Yeah.
Yes, Sharma ji, please
Indeed,
carry on.
indeed, your lordship.
Yeah, you compared right of privacy with the wrong and a crime committed. Means then you made a generic sense out of the wrong, out of the crime committed by certain individuals. So right to privacy, qua the individuals and qua a person who is on the wrong side of the law are totally different things. I mean, so we can compare those things. Sir has already mentioned about the constitutional morality, public morality. So I would have first issue is that in your brief at point 42 you have mentioned that Information Technology Act was passed to govern the law of electronic means of communication. The act was passed to provide a safe haven on online platforms, but it contains no provisions about acts such as cyber stalking, cyber defamation. So that's one submission you made, and then you said that Article Section 354D will not be applicable. IPC section will not be applicable because there is a specific provision in a law. But you yourself has given in that your brief that there is no special provision qua stalking, cyber defamation, or voyeurism. It is an act of voyeurism which has been committed in this particular section. So when there is no specific provision contained in the IT Act, how do you say that Section 354D will not be applicable?
So, your lordship, that is what the council contended, and what is the requirement of the guidelines is there because of such acts are being committed, and it is the same is required by the court to pass such guidelines, so to ensure that such acts do not take place. Moreover, your lordship, as the council stated, the case of Sharad Babu.
I must clarify to you, the position in law is always this: if suppose there is a special act which has been enacted by the parliament, and then the special act will supersede in all eventualities the general act. So IPC being the general act, but when there is no provision for certain action, certain crime in that particular special act, then the general act will come to prescribe that punishment for that crime. So it cannot be said that now the Supreme Court is going to pass a guideline with regard to that. All right, this the punishment for such an act should be this, when already in a general act it has been provided. So then we would be guided by the principles of those sections which are governing that particular act.
Your Lordship, in the present case, we also see that Your Lordship, as the council contended that how the provisions are not there in the at present. Moreover, Your Lordship, even though they want to apply even though the General Act could be applied, there have been many cases where it has been said that all such offences need to be covered under IT Act only, and as the council stated, as per the legal maximum only as well, that specific law needs to prevail over the general law. So keeping that in mind, that's what the council submitted and contended.
Very well. Continue. Please continue.
If there are no other questions, the council seeks permission to move to the prayer.
I am sorry to interrupt. We have Advocate Adish Agarwal as well with us. So if you wish to ask any questions.
I think he has left.
All right.
Then we can move on. Yeah. It's okay, Mr. Sharma. Thank you very much.
Sir, I'll just complete my prayer. Yeah. Wherefore, in the light of the facts of the case, issues raised, arguments advanced, and authorities cited, this honorable court may be pleased to hold the present rate petition maintainable, declare Section 74, Subclause 3 of the Juvenile Justice Care and Protection of Children Act 2015 as constitutionally invalid, declare that publication of news reports is violative of right of privacy under Article 21 of Constitution of Bhavani, declare that right of freedom of speech and expression of the members of Bros locker room under Article 19 of Constitution of Bhavani has been violated, hold that honorable court should pass guidelines and direction in relation to practices of cyber stalking and cyberbullying, and or pass any other order that it may deem fit in the interest of justice, equity, good conscience, and for the same the council for petitioners shall forever humbly pray.
Thank you, Mr. Sharma. Thank you very much. So we can move on further.
Sakshi, we can't hear you. No voice. Sakshi, we can't hear you.
Yes, Sakshi ji, carry on.
With the permission of this honorable court, the council would like to start with the oral arguments.
Yes, carry on.
Much obliged, your lordships. The respondents would seek permission from this honorable court to refer to the bench collectively as your lordship on behalf of both the council members.
Yes, please carry on.
Much obliged. Your lordships, the respondents have been brought before the Honorable Supreme Court of Bhavani as the petitioners claim violation of their fundamental rights. Your lordship, this is counsel number 1 appearing on behalf of the respondents in the case of ex-minor through his guardian and others versus the Union of Bhavani, and would be dealing with issues 1 and 2, and my co-counsel would be dealing with issue number 3. Here we are representing the Indraprastha police, the Frankal and the Mint, which are the media houses, as well as the victims in the present case. Issue number 1 deals with maintainability of the writ petition. Issue number 2 deals with Section 74 of the Juvenile Justice Act of 2015. And issue number 3 deals with Section 67, 67A and 67B of the IT Act. Now, if your lordships are well versed with the facts of the case, the council would like to start with the oral arguments.
Yeah, please carry on.
Much obliged. Your Lordships, issue number 1 deals with the question that whether the present writ petition is maintainable before the Honorable Supreme Court of Bhavani. Your Lordships, as we are all aware of the fact that the writ petition is filed in the Supreme Court when there is violation of fundamental rights by the government authorities, so that the court could issue directions in the nature of habeas corpus, mandamus, certiorari, quo warranto, and prohibition. And looking at the present case, the council would like to submit to the court that there has neither been violation of any fundamental rights nor any legal injury has been done to the petitioners. The council would like to elaborate on the fact that why the present petition shouldn't be maintainable before this Honorable Supreme Court of Bhavani. Your Lordships, the first and the foremost reason being the petitioners say that the arrest of the alleged members of the group was illegal. But the fact that the arrest which the petitioners claim to be illegal cannot be said to be illegal because the alleged members of the group have committed offences under Section 67B, which gives punishment for publishing or transmitting material depicting children in sexually explicit act in the electronic form, and Section 66E, which lays down punishment for violation of privacy of the IT Act. Furthermore, the petitioners have also committed offences under Section 499 and 500 of the IPC, which deals with criminal intimidation, which deals with defamation and punishment for defamation, as well as Section 503, 507, and 509 of the IPC, which deals with criminal intimidation by anonymous communication, insulting the modesty of a woman, respectively, and an offence has also been committed under Section 4B of the Indecent Representation of the Women's Act of 1986. So the arrest was just a result of the said offences. Secondly, the petitioners also say that there has been violation of their right to privacy as their identity was disclosed by the police authorities. Here, the council would like to clarify that the disclosure of identity by the police authorities to the media houses was only done to make sure that more young girls or women do not get trapped in this vicious cycle of social media. If we go by the laws, then the state cannot itself claim the right of being compensated against its own officers. And to prove this, if your Lordships could please refer to page 10 of the memorial, first para, in the case of A Registered versus Union of India, my lords have held that the state cannot itself claim the right of being compensated in damages against its own officers on the ground that they have contravened or violated the fundamental rights of the citizens. Thirdly, the petitioners claim that there has been a violation of their right to freedom of speech and expression. But your Lordships, we all are well aware of the fact that Article 19(1)(a) of the Constitution comes with reasonable restrictions under Article 19(2), which in fact the petitioners have violated by not abiding to the clause of obscenity and morality. If your Lordships could please refer to page 11 of the memorial, in the case of D.M. Wayanad Institute of Medical versus the Union of India, the Honorable Supreme Court held that in order to establish the violation of fundamental right, the court has to consider direct and inevitable consequences of the action which is sought to be remedied or the guarantee of which is sought to be enforced. And in the present case, as there exists no direct nexus between violation of fundamental rights and the remedies sought, the present writ petition is not maintainable in the Supreme Court of Bhavani. Your Lordships, each fundamental right will be dealt with separately in the further arguments. Now, if your Lordships are satisfied, the Council would like to proceed to the next issue.
Yes, very nice. Go ahead.
Much obliged. Your Lordships, issue number 2 deals with the question that whether Section 74(3) of the Juvenile Justice Act of 2015 is pari materia to Article 21 of the Constitution on the grounds that the punishment mentioned under the clause is inadequate and insufficient. The Council would like to explain this particular issue in 3 parts. The first part being that there has been no violation of Section 74 of the Juvenile Justice Act of 2015. Your Lordship, Section 74 lays down prohibition on disclosure of identity of children, and the Council is well aware of the fact that this identity shouldn't be disclosed at any stage of investigation by any of the public authorities. But the fact that needs to be taken into consideration is that the identity of these alleged 22 members was already disclosed by a non-member of the group. Now, even if we ignore this fact and say that the police authorities have disclosed the identities of these juveniles to the reputed media houses, then the only reason behind this was public safety. owning to the fact that these juveniles were giving rape threats to girls and women who tried to raise their voices. Your Lordships, my second part of the argument deals with right to privacy of the victims. Your Lordships, of course, Section 74 stands for juveniles who are in conflict with the law. But then what about the victims whose morphed pictures have been used? What about the alleged members body shaming the girls? What about rape threats given to the victims by the alleged 22 members? Are we even considering the fact that even their identities were disclosed without them even being a part of all of this? Now, your Lordships, you might ask about what about those boys out of the 22 members who might not have even committed an offense. So for that, the council would like to clarify that and give an example that rape is an offense under the IPC, and so is accompanying a rapist, which basically means the action of instigating, encouraging, or promoting a person into committing an offense, which means that even if some members of the group wouldn't have actually committed the crime, but neither have they reported for the crime, which calls for an offense under the IPC, abetment of crime is an offense under Section 107 of the IPC. Thirdly, it says that a person who, by willful misrepresentation or by willful concealment of a material fact which he is bound to disclose, voluntarily causes or procures or attempts to cause or procure a thing to be done, is said to instigate the doing of that thing. And the willful concealment of facts has been done in the present case. If your Lordships could please refer to page 13 of the memorial, last para, third line. The Supreme Court in the case of Shreya Singhal versus Union of India held that while in the case of internet, morphing of images, change of voices, and many other technologically advanced methods to create serious potential social disorders can be applied. Internet can invade upon the privacy of an individual and thereby violate their right to life and personal liberty guaranteed to them under Article 21 of the Constitution. Indeed, but only if we could look into Article 21, which states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. The publication of any of the foresaid personal information without the consent of the person, which hasn't been taken in the present case, whether accurate or inaccurate, and whether laudatory or critical, would be in violation of the right to privacy of the person and liable for damages. The exception being when a person voluntarily invites controversy or such publication is based on public records, then there is no violation of privacy. If your Lordships could please refer to page 13 of the memorial in the case of Raj Gopal versus the state of Tamil Nadu, in which the Supreme Court held that the right to privacy is implicit in the right to life and liberty guaranteed to the citizens under Article 21 of the Constitution. The victim girls in the present case, as well as the women, fall within the ambit of Article 21, whose right to privacy has been violated in the present case. In fact, rather than the petitioners, that is the alleged members, the right to privacy of the victim girls and women have been infringed. This brings me to the third and the last part of my issue, which talks about the punishment mentioned under under Section 74(3) is perfectly justified. It states that any person who contravenes the provisions mentioned under subsection 1 of the said act, that is disclosure of identity, would be punishable with imprisonment for a term which may extend to 6 months or a fine of 2 lakh rupees or with both. And considering the fact that girls have been objectified, rape has been glorified, and women have been threatened, whatever the police authorities have done is not because they had any personal grudges with the 22 members, but because the safety of the general public was more important to them. Furthermore, the facts of the case clearly indicate that the 22 members have committed offences under not just Section 66E, Section 67 and 67B of the IT Act, but also under several sections of the IPC. If your Lordships could please refer to page 14 of the memorial, the Delhi High Court in the case of S.K. Bhala versus the state and others held that intention is the basic ingredient of the offence under Section 509 of the IPC, and this intention is quite visible in the present case. So the council would like to conclude by saying that even if the police authorities have acted beyond their arbitrary actions, this case should be considered to be an exception Because in the present case, the question is not what the respondents want, but it is about what they do not want. And to be specific, the respondents do not want the alleged members to be set free from the clutches of law on the mere fact that these alleged members are juveniles. If your lordships are satisfied with the second issue, I would like request my co-counsel to deal with the third issue, your lordships.
I have a question to ask Ms. Sakshi.
Yes, your lordship.
So you stated that in the public interest, the names of the juveniles in conflict were disclosed to the media houses.
Yes.
Am I right?
Yes, your
So
lordship.
I wanted to know what do you consider whether Section 74 of the Juvenile Justice Act, with regard to its applicability, whether it would be applicable on the police authorities or not? Are you making a submission? Let me clarify furthermore. Are you making a submission that Section 74 will not be applicable on the police authority and they may decide as per their own whims and their own fancies when to disclose the names and when not to disclose? Whether the statutory law would be prevail over the police action or the police action will prevail over the statutory act?
Your lordships, the council is well aware of the fact that section 74 does not give any explicit condition to expose the names of the juveniles. Absolutely no, your lordships. But we are well aware of the fact that constitution prevails when all the acts fail, which means that the constitution stands above the IPC and the IT acts. Here, article 21 of the victims has been violated. The arrest cannot be said to be illegal because the alleged members of the group come under the garb of section 67D of the IT Act for transmitting pictures of young girls who were as young as 14. And the arrest was done in the interest of the general public so that more girls don't get trapped in this vicious cycle. In the case of Lala Ram by LR and others, the Supreme Court held that a welfare state must serve larger public interest. Salus populi as suprema lex, a legal maxim which says that the welfare of the public is the supreme law. A state instrumentality must serve the society as a whole and must not grant unwarranted favors to a particular class of people without any justification at the cost of others, which are victims in the present case, your lordships. And in the clash between two fundamental rights, the right which involves larger public interest prevails. I hope your lordships are satisfied.
I'm not sure whether there is a clash between two fundamental rights. If the law will take not effect, then what will take effect? The law has to take effect. So if there is a section prescribing non-disclosure, this is a requirement under law, then all the people serving the law are under the mandate to follow that law. They cannot decide the law themselves. If you have cited certain cases, I'll cite one case, the Kasab's case. Everybody knew that he had committed that kind of crime in flagrant way, and despite that, the Indian courts granted him the right to defend himself. So everything has to come, means law is supreme, not the actions. So the police authorities were under the obligation to follow that law, and Section 34 was required to be followed in this case also. And then, means contrary to your own prayer with regard to Section 74, then you are also saying this is Section 74 is applicable. So it is either applicable or it is not applicable. So if you say that it is applicable, then certainly there is a violation of violation carried by the police official. So let's move forward.
Yeah, your lordships, if you are satisfied, I would like my co-counsel to move with the next issue, your lordships.
Well, Sakshi, there's one question.
Yes, your lordship.
One of your submission was that it was in the public's interest, that is for the public safety, so the other innocent girls may not get trapped in the group. So that it was one of the reasons for the police, besides the reason that some of the non-group member had already disclosed their names. Don't you think that the public safety could be ensured by the police by other means other than disclosing names, number one? like making a general appeal to the public to avoid such groups and be careful of such groups who are working on these lines. This is one. And secondly, don't you think that by disclosing the names of the boys and highlighting in the media, the police and the media has caused more harms to the general public, particularly the victims, the girls, since their names are also in the public. So they were not known, they were not in the public domain before these names of the boys were disclosed. So instead of giving any relief to the victims, rather, don't you think that they have caused more harm to the victims? And is in violation of Section 74. Yeah, please carry on.
Yes, absolutely, your lordships. But the fact that needs to be taken into consideration that the identity of the alleged 22 members was already disclosed by a non-member of the group. Now, even if we ignore this fact and say that the police authorities have disclosed, your lordships, of course, they didn't had any personal grudges against the 22 members. They just wanted to make sure that more girls don't get trapped in this vicious cycle, your lordships.
Well, by disclosing the identity of the boys, don't you think that they have caused more harm to the victims, the girls also, who are being exploited in the group by different means? So police should have. Don't you think that the police should have been more restrained instead of going to the media and giving the names of the public, even if they had known the names from some non-group member? But I think that police should have used some more restraint instead of going to the media state and disclosing the names, because they seem to have overlooked that by giving the names of the boys, the names of the girls will also be in public domain, and they are causing more harm to the victims. So the right of privacy gets, both the rights of privacy of both the boys and the girls gets damaged. And when particularly there is a law of Section 74 which prohibits disclosure.
Absolutely, your lordships. But then the larger public interest is taken into consideration here when the victims are more in number, and the 20. We are well aware of the fact that the 22 members have committed an offence under several sections of the IT Act as well as IPC. The police thought that the safety of the general public, that is the girls, victims in the present case, was more important, your lordships.
Okay, you can move on further.
I would request my co-counsel to deal with issue number 3, your lordships.
Yeah, please carry on. Thank you.
Much obliged.
This is counsel number 2 appearing on behalf of the respondents in the matter of X the minor through his legal guardian versus Union of Bhavani. Your Lordship, counsel number 2 shall be dealing with issue number 3 and shall be stating the argument advanced on the question of validity of section 67B of the Information Technology Act. Before beginning with my main argument, I would like to ponder upon the question of law which my lords asked to the petitioners, and which my lord may kindly refer to page number 11, 5.1 of the petitioner's memorial, where they have explicitly stated that the present act is said to be inadequate in nature, and the act they are talking about is the IT Act, where they have stated that because there is no provision of cyber stalking and cyber bullying, the act is said to be inadequate in nature. Your Lordship also asked the question whether section 354 is covered. My Lordship may kindly refer to section 354D of IPC. It itself states, the second paragraph, that monitors the use by a woman of the internet, email, or any other form of electronic communication commits the offense of stalking. Your Lordship, this is a direct legislation which states that any stalking done on the internet media is punishable. Then on what question is the petitioner asking the question that stalking, cyber stalking, is not given under a specific legislation? The second question was of cyber bullying. Now, my lords, in SMC Pneumatics Private Limited versus Jogeshwar Quatra, has held that Defamatory, obscene, derogatory, humiliating, and threatening messages on internet media shall amount to cyberbullying, and has upheld that Section 503 of the IPC stands for the same. Now, if both of these sections, that is Section 354 D, which constitutes of stalking, and Section 503 of IPC deals with cyberbullying, and then on what question does the petitioner ask the respondent that the present act, that is the Information Technology Act, is to be considered as inadequate? Stating the same, I would like to proceed with my main argument, that is issue number 3. Coming to issue number 3, which asks us the question whether the Information Technology Act's criminalization of private communication in electronic form be justified as a reasonable restriction under Article 19(2) of the Constitution of Bhavani, and whether the disclosing of the identity of the juveniles by the police officials and the media houses be considered as an arbitrary action, striking at Article 14 of the Constitution. Your Lordship, the respondent would like to humbly contend before this Honorable Court that the criminalization of private communication under the Information Technology Act in electronic form is justified as a reasonable restriction under Article 19, Clause 2 of the Constitution of Bhavani. In order to prove my arguments further, I would like to divide it into 3 equal folds. Firstly, I shall be dealing with the essence of the Section 67 and 67B of the Information Technology Act. Secondly, I shall be dealing as to how there has been no violation of Article 19(1)A of the Constitution of Bhavani. And thirdly, I shall be dealing as to how there has been no violation of Article 14 by the police officials and the media houses. Your Lordship, coming to the first fold of my argument, which talks about the essence of Section 67 and 67B of the Information Technology Act. Your Lordship, after careful perusal of the petition made by the petitioner, there is no reference of Section 67 nor 67B of the Information Technology Act, which actually criminalizes private communication done under in group chats or even private individual. The Section 67 punishes and criminalizes transmitting obscene material in electronic form, whereas Section 67D punishes and criminalizes for transmitting material which depicts children in sexually explicit action. Now, Your Lordship, which means that this section punishes for transmitting material which ignites salacious mind and annihilate the essence of reasonable restriction mentioned under Article 19, Clause 2 of the Constitution of Bhavani. Now, there is a constant use of the term called as obscene, which is totally ambiguous until my lords in Devidas Ramchandra Tulsapurkar versus State of Maharashtra has explicitly explained the meaning of the term obscenity. My lords have stated that the word obscene means was originally used to describe anything disgusting, repulsive, filthy, or foul. The use of the word is now said to be somewhat archaic. However, it is ordinarily restricted to something offensive to modesty or decency, expressing or suggesting unchaste or lustful ideas, or being impure, indecent, or lewd. Your Lordship, all of these adjectives which my lords have stated in Devidas Tulsapurkar has been done in the present case by these accused boys. They have been sending obscene material in the group and have been commenting on the same with their lustful ideas being ignited, and which shows that this is an obscene act. Now, moving forward to my second fold of the argument, which talks about the violation of Article 19(1)A. My lords, it is the humble submission of the respondent that Section 67A and Section 67B criminalizes offensive internet media and chats which are under the realm of reasonable restriction mentioned under Article 19, Clause 2 of the Constitution of Bhavani. My lords, it may grant me the permission to read the last few lines of Article 19(2), which states that Article 19(2) imposes reasonable restriction in the interest of sovereignty, integrity, security, friendly relation, public order, Your Lordship, morality or decency, defamation or incitement of an offense. These 4 adjectives shall be dealt by the council in detail in the further argument. But before the same, my council have said in their memorial, page number 11, on the 96th footnote, where they have stated that private chat should remain private because it is done in the realm of privacy. My Lordship, it is a very simple question from the respondent that if there is any kind of offense such as cyber terrorism or terrorist activities which is being discussed in the realm of privacy, which is being discussed in private group chats among 3 or 4 individuals, will that be acceptable by this law after the terrorism being done? The answer is an absolute no, because it is a reasonable restriction under Article 19, Clause 2 of the Constitution of Bhavani, which says that integrity and security of the state is a reasonable restriction of Article 19(1)(a). In the similar manner, Your Lordship, decency, morality, defamation, incitement of an offense is also a reasonable restriction under Article 19(1)(a). Now, to prove the same, the Council shall be dealing with each of these 4 adjectives in separate manner. Coming to the first one, which talks about indecency. Now, my lord may kindly refer to compendium page number 7, the highlighted portion. The compendium of the respondent states that Section 2C of the Indecent Representation of Women's Act defined indecent representation of women. Section 2C states that verbatim, the depiction in any manner of the figure of a woman, her form or a body or any part thereof in such a way as to have the effect of being indecent, derogatory, or is likely to deprave or corrupt the mind or injure public morality or morals. My lordships, I would like to humbly contend that the members of the Bros locker room has openly talked about the body of these underage girls who are as young as 14 years of age. They've compared the size of their breast to the size of their beauty, and they have allegedly uploaded mocked or nude photograph pictures of these girls in the group, thereby displaying indecent behavior, indecent activities in the group, which was also leaked by the non-member. Your Lordship, which means there is a lacuna that a non-member could also get access to these group chats, which directly means it is not a private group chat, my lords. Even if 1 or 2 members of the private group chat leak such an image, it is going to reach the public, as it already did in the present case. Coming to the second adjective, my lords, which talks about immorality. Now, my lords, in Ranjit B. Uddeshi versus State of Maharashtra, has upheld the principle which was given in the English judgment of R versus Hickling, where the Honorable Court said that a publication is said to be obscene if it tends to produce the lascivious thoughts and arouses lustful ideas. Your Lordship, once again, these messages which were sent in the group have displayed a sheer display of lustful thoughts coming in the mind of these juvenile young boys. And even if it is not seen directly, Your Lordship, they have passed derogatory statement even against those women who have revealed their offense in front of law. They have also not only committed the crime of threatening women and giving rape threat once, but twice in the Bros locker room 2.0, which means these young juveniles are not to stop with just a warning in a juvenile home. They are supposed to be conducted before the trial, and they are supposed to be given adequate punishment because they are committing myriad number of offenses which is punishable before the law. Coming to the third adjective which is placed under Article 19(2), my lords, which talks about defamation. Now, my lords, the respondent is well aware of the fact that Section 499 and Section 500 of the IPC deals with defamation. But my lords of Supreme Court in Subramanian Swamy versus Union of India, which is given under page number 2 of the compendium of the respondent, the highlighted portion states that, if I may quote verbatim, one cannot be unmindful that the right to freedom of speech and expression is a highly valued and cherished right, but the Constitution conceives of reasonable restriction. In that context, criminal defamation, which is in existence in the form of Section 499 and 500 of the IPC, is not a restriction on free speech that can be categorized as disproportionate. Right to free speech cannot mean that a citizen can defame the other. Protection of reputation is a fundamental right. Your Lordship, not have these juveniles done the act of defaming these young women. The right to reputation of these young women, these young victims of even 14 years old, have been taken away. The facet of Article 21, which my Lordship have stated in Srimati Kiran Bedi versus the Committee of Inquiry, verbatim stated that the right to reputation is a facet of right to life of a citizen under Article 21 of the Constitution, nor have they actually committed Section 499 and 500 of the Indian Penal Code, but have also infringed and violated the fundamental right under Article 21 of the Constitution of Bhavani. Coming to the fourth and the last adjective mentioned under Article 19(2), which talks about incitement of an offense. Your Lordship, the word offense is not actually defined under the Constitution of India, but it is defined under the General Clauses Act, which means offense shall mean any of the crime or omission made punishable by any law for the time being enforced, which means all the section in IPC, even the IT Act, and maybe even the Juvenile Justice Act can be applicable in the present situation, which brings me to the point which the actual petitioner has contended. They said that it is a petty offense, serious offense, and there is something called as the heinous offense in the Juvenile Justice Act, for which only the offense which is a heinous offense, that is where the the punishment is more than 7 years, the FIR can be registered. Your Lordship, the respondent would like to humbly submit that it is not just one section that the accused have committed. They have committed a myriad number of sections, of which together, if the punishment is calculated, is definitely more than 7 years of imprisonment. Your Lordship, if I may note, they have committed the section of 499 and section 503 of the Indian Penal Code for defaming the reputation and maligning the reputation of a young woman, section 507 of the IPC for threatening women who reveal their lascivious chats, of section 509 of the IPC for outraging the modesty of young women, section 4B of the Indecent Representation of Women's Act for publishing indecent image of women on online platform, section 67B, section 66E of the IT Act, and so many so. Your Lordship, it is not just one where they are categorizing it to be a serious offense. It is a heinous offense if all of these punishments are compared together and the trial is based on the same. Now, coming to the third fold of my argument, which talks about there has been no violation of Article 14 of the petitioner. Your Lordship, the respondent in the present case have not acted beyond their adequate power and have acted on established principle of criminal law and thereby have not committed an arbitrary action. Now, my lords, for the purpose of Article 14, in Sharma Transport versus Government of Andhra Pradesh, has explicitly explained the meaning of what arbitrarily means. It means that an action which is done in an unreasonable manner, as fixed or done capriciously or at pleasure without adequate determining principle, not founded on the nature of things, non-rational, or acting according to the reason or judgment depending on the own will. Your Lordship, in the present case, the police officials have not arbitrarily arrested the juveniles, but have done so due to its powers conferred under Section 67B and to protect the public interest of the larger public. Now, which brings me to the point made by counsel number 1, where she stated that there is no intelligible differentia between the victims of the crime and between the juveniles in conflict with law. Your Lordship, there isn't an intelligible differentia because the present action of the police, which is done of disclosing the identity of the juvenile, has been done in the interest of the public. Now, my lords, in Lala Ram by LR and others versus Union of India, has stated that salus populi est suprema lex, which means the larger public interest in context to the lower public interest will be upheld any day in front of the question of law. Now, the other question which was put by my learned counsel from the petitioner side, which they stated that their section 74 subsection 3 of the Juvenile Justice Act must be struck down on the grounds that it is unconstitutional. Your Lordship, the respondent is not able to understand what the petitioners want from this honorable court, because section 74 of the Juvenile Justice Act is the act which actually punishes disclosing of the identity of the juveniles. And if the petitioner is stating that section 74 itself, the punishment itself must be declared as unconstitutional, then on what grounds is the petitioners even approaching this honorable court stating that the punishment itself is inadequate and must be struck down on the basis of unconstitutional? Your Lordship, the respondent is trying to learn the fact that what the petitioners want from this honorable court. Now, further, Your Lordship, if you may ask me why was the identity of disclosing the identity of the juveniles done by the police official? Your Lordship, it is a very important fact that even if a crime is done in the privacy of a group chat or in the privacy of private chat, the right to have living to the right to be living as a dignified human, the right to be living without having sexual harassment or sexual abuse on a person is a fundamental right under Article 21, which my lordship has stated in Vishakha versus State of Rajasthan verbatim. The meaning and content of fundamental right guaranteed in the Constitution of India are of sufficient amplitude to encompass all facets of gender equality, including prevention of sexual harassment or abuse. Your Lordship, just like the council stated before in our argument that would the state or even this court agree on the fact that cyber terrorism or terrorism is being construed in the privacy of a private chat? Absolutely no, Your Lordship. This is why even the police have acted in its power to curb this activity which was done by these juveniles, to curb the activities of sexual harassment or abuse which have been conducted in their so-called realm of privacy, which Section 67B absolutely punishes before the question of law. If my lords are satisfied, may the council proceed to the prayers.
Yes, please carry on.
Yes. In the light of the issues, argument advanced and authority, respondent has urged the honorable court of parties to dismiss the present and in doing so, adjudge and declare that A, the respondents have not violated the fundamental right of the petitioners whatsoever. B, Section 67 and Section 67B of the Information Technology Act 2000 are intra-vires to the Constitution of Bhavani. And third, the declaration of the names of the juveniles in conflict with law by the police authorities and the media houses was an act done in public interest and is an act to the Constitution of Bhavani and pass any other order in the interest of justice and equity. Much obliged, Your Lordship. It was a pleasure arguing before this honorable court.
If the council seeks permission to start with the rebuttals.
Yes, please carry on.
Much obliged. I also request my co-counsel Harsha ma'am to please mute her. Thank you, ma'am. Your Lordship, starting with the rebuttals, the first point is that the violation of fundamental rights has already been proven by by my co-counsel one. Secondly, even if, as the council stated the case of Vineet Kumar as well, that even if there is a wrong which is being done, the same does not give you or absolve you of the liability that you are taking a person's fundamental right to privacy. Third is that it has also been proven that respondents 3 and 4 will be can be held to be liable for their acts. Fourth is, Your Lordship, that even though any act has been committed which is wrongful in nature, the police have no right to go ahead and violate the Juvenile Justice Act. Secondly, it hasn't been proven anywhere that this act which has been done by them is going ahead to do to save any sort of harm in the present case. Fifthly, as our respected counsel said, that there is no direct consequence of such publication. However, page 4, para 11 clearly states that there have been protests, there have been aggressive attacks on the family members of the accused, which shows that there are direct consequences. Next is that even though they want to do such a disclosure in the interest of public safety, but the council would like to say, as Your Lordship also pointed out, in the case of Kasab, the procedure was followed. In the case of Nirbhaya as well, no names or identity was disclosed, and where the media houses come into play here is that they are reputed media houses. They have much more larger social influence and can influence people in such a manner. Secondly, they say that rape threats have been given, derogatory messages have been given. However, on page 3, para 8, we see that this is from Gross Locker Room 2.0, O, not anything. It has nothing to do with the first group which is there, and this is not clear whether this Bros Locker Room 2 consists of the same members which were there in Bros Locker Room 1. Next is they themselves agreed at one point that it is they allegedly shared nude and morphed photos. This was never clear whether or it was proven that whether such photos have been proved. Next, rape has never been, it is nowhere mentioned in the factual matters that rape has been glorified. There is no abetment of crime as well. Moreover, your lordship, my respected co-counsel stated that cyber terrorism is being done. However, cyber terrorism refers to acts which affect the security and sovereignty of the country. So the council of the petitioners failed to understand how due to the acts the security or sovereignty of the country are getting affected. Moreover, even though offense has been committed, the same does not mean that they can go ahead and violate the law. For example, the same has to procedure has to be followed, the trial needs to be there. Moreover, the question of incitement has not been covered, and my respected co-counsel also stated that the police is empowered to go ahead and take such actions. However, according to Rule 10, subclause 9 of Model Rules of JJ Act, which clearly state that no FIR can be filed till the time the punishment is more than 7 years. More than 7 years. So such addition of the number of punishments cannot be done as well. Moreover, your lordship, as the council stated that we have missed out on the points of 67A and 67B, the council in his own pleadings contended on the points that even though such points are there, there are such provisions such as cyberbullying and cyber stalking which are still not been covered. Moreover, your lordship, they also the number of victims has not been mentioned, and these are all the rebuttals. Thank you.
May the council proceed with sir rebuttal with the permission of your lordships? Is there a provision for the same?
Yeah, please carry on.
Much obliged, your lordship.
But be precise.
Yes, absolutely. Your lordship,
Yeah.
all of the contention which has been placed by my learned co-counsel of the petitioner's side is a matter of actual fact. The factual manner is not supposed to be dealt by the Honorable Supreme Court, and the Honorable Supreme Court is not a fact-finding body. And proceeding to the question of law which has been put by the learned counsel of the petitioner's side is that is talking about cyber terrorism. Your lordship and myself is well aware of the fact that the council was just giving an example in the garb of Article 19.2, of which Article 19.2 states that integrity and the security of the state is a reasonable restriction, and so is decency and morality. That was just an example and not an actual crime in the present matter, of which I am sure that my honorable bench and as well the council is aware of. And thirdly, the council spoke about the act being inadequate of cyberbullying and cyber stalking. The same question has been dealt by the council in the argument. The council of the petitioner's side is unsure of the rebuttals because they have not been actually going through the arguments placed by the respondent, and which is a sad state of affairs. Much obliged, your lordship. That's it from the respondent side.
Yes. So it's all. It's over. Your presentation is over. Thank you very much.
Your lordships, if your lordships could give all of us a feedback.
You want to say something, Meenakshi?
Your lordships, if it would please, both of you, could you please give us a feedback, all of us?
Okay, go ahead. Yeah.
I'm sorry to interrupt, sir. Sir, teams are asking for feedback.
I'm not getting the question what she said.
Sir, she's asking for feedback.
Feedback. Okay. Feedback of the presentation you're talking about?
Yes, sir. The presentations of both the teams, of all the participants.
Okay. Feedback of the presentation of both the parties is really beyond my expectation. It has been really beyond my expectation. I did not expect that the participants who are the who are going to be young lawyers. I think there's somebody has to mute it.
Yes, so please continue.
Well, yeah, I was saying that the participation and the presentation of both the teams participants are really beyond my expectation. I never expected that the participants would be so confident, so well prepared, and this is really rather I do not see such class of lawyers in my court. They are really, all of them are going to be very good lawyers, and certainly the girls are taking edge over the boys. That's another important aspect of the 2 days final round of competition. So both the teams, I must compliment each and every one of them about their preparation and the kind of assistance and the research they have done. Whosoever have assisted them, they have also done wonderful jobs, and the presentation of each and every one is really marvelous, exceptionally well prepared and well presented. So, well, it is going to be a very tough for us to make a decision as to who is the best, because one has to assess. So in that scenario, we will be evaluating each and every one of them and also the team. But nevertheless, none is less than the other. So it's going to be very tough for us to make a decision with regard to their presentation. I must compliment each one of them again. And really, I'm really delighted to see their confidence, to see their preparation, to see their presentation, to see their body language, their articulation, analysis of the law and the facts. Excellent. So I must congratulate you, Atin, that you have organized.
Thank you, sir.
And brought to this level. And I'm very sure that both the teams, wherever they are studying, I don't know because this is all confidential. So wherever they are studying, really some of the credit goes to their institutions, but more credit goes to their own preparation, their own confidence, and their own everything. And of course, those who are a part of their teams, who are in assisting in researching, and the guidance under whom they have taken. Excellent. So each and every word of my heart is speaking about the good participation, and they are very my co-judge Sharma may also share his views. This is what I have observed. Thank you.
Totally agree with you, sir. Means it's a wonderful presentation that has been made, and with a deep knowledge of law. Not only means it was not a surface knowledge. I'm really pleased to hear all of you. All of you did wonderfully well, and at the same time you responded well also to the questions. Of course, means there are good facts, there are bad facts. So while we judge the Moot course, we are not concerned about the good facts and bad facts. There is a good case on one side and the bad case for the other side. The only thing that I want to just improvise on in your step is, in law what we call means at moot court level, at so many times you have to imagine certain facts. So that imagination, when you do in actual practice, it is called legal fiction. Legal fiction is something means that connects the dots to in the most logical, plausible, and most probable manner. So, for example, in the present problem, there was a point when the public disclosure was not required to be made by the authority people. So there were two stands on that point. It means the fact and law do not support our contention and argument at times in which public disclosure was totally illegal and unlawful. So it was very difficult to defend by the people who were defending that public disclosure. But at the same time, there was a thin line, there was a silver lining also in their favor, in the favor of petitioner side team, that the disclosure was already made. The silver lining was for the respondent team. that the disclosure was already made by a group member in a public domain. So then you do not need to raise any other argument except that one argument that the disclosure was already made. So subsequent disclosure had no meaning, therefore means no culpability can be arrived at because of that subsequent disclosure, because it had already been there. So I would just add to you that you could not, were not required to give any other argument at all in law, because the disclosure is already there. Something which has become public means if it has been subsequently disclosed, it has already been in public domain. So it means it was beyond your control to really stop it from flowing. Baki means rest of the points were excellent and remarkable, and sir has absolutely correctly mentioned that all of you have done very good preparation. I really liked your confidence, your presentation, and the way you handle the entire brief. So my best wishes to all, and one has to win, of course, but I am telling you, both the teams have really competed very well. My best wishes to you.
Thank you,
Adish
sir.
sir,
Thank you, sir.
Thank you, Your Lordships. Thank you.
Adish sir, can you hear me? Yes, sir. Adish sir, can you hear me?
Yes, yes.
Yes, sir. Please give your reviews to the team, feedback to the team.
Both teams have worked very hard, and this is a new concept now because now it is on this video. Earlier, we used to see, observe them when we were having moot court competition physically. So, but from this video itself, we can come to conclusion that both teams have worked very hard in preparing their pleadings and then in their arguments. So both teams have very good presentation. How they know the art of presentation and argument. I congratulate both teams for coming to this stage, and now our Justice Mehta and Mr. Sharma ji, we will decide who will be the first and second. Thank you.
Thank you so much, Justice Mohanlal Mehta sir, for your time for judging the finals. Mr. Vivek Narayan Sharma sir, Mr. Adish Agarwal for judging the final rounds. Now we'll having the results at 1:30, and the link has already been shared to you. And Justice Mehta will announce the results in front of you at 1:30. Thank you.
Thank you.
Thank you.
Thank you so much for the organization
Thank
of the
you, sir.
event. Thank you. It was great.
Thank you.
Thank you.
Thank you. It was
Thank you.
amazing.
Thank you, everybody. Thank you.
Now you can leave the session and see you at 1:30.
Thank you, sir.
Yes, sir. Thank you.
Thank you very much, sir.
You have, Jatin, you have shared the sheet of the result with us?
Yes, sir. I've shared the sheet to mark the teams.
That is on email you're talking?
So I've shared it on WhatsApp. I'm just mailing you.
Achha, okay.
Vivek sir, I've shared it with you as well. And Adish sir, to you as well.
Vivek sir has left the meeting again.
Please stop the recording. Sir,